Anyway, we've been covering points and key places during this Devyn Michaels trial. And as some of you may have seen, Devyn Michaels was found guilty. We're going to actually get into the verdict being read here, and then we're going to go back and do a little bit of a rewind and see what her defense had to say during closing arguments, because that's going to be very interesting and key into parts of this verdict and later on into the sentencing. So check this out. We'll get right into it. Devyn Michaels, she's going to be in jail for a while.
Person, has the jury reached a verdict?
Yes.
If you could pass the verdict form to the marshal. All right, the clerk will now read the verdict into the record.
District Court, Clark County, Nevada. State of Nevada plaintiff versus Devyn Jade Michaels, aka Devyn Willett, aka Nikki Fairchild, aka Tracy Baker, aka Tracy Nicole Tavares, defendant. Case number C-23-377-239-1, Department 10. Verdict. We, the jury, in the above entitled case, find the defendant, Devyn Jade Michaels, as follows. Count 1, murder with use of a deadly weapon. Guilty of first-degree murder with use of a deadly weapon. Dated this 14th day of November, 2025, signed Aaron Gilded. Ladies and gentlemen of the jury, is this your verdict as read? So say you one, so say you all?
Yes.
Does either side desire to have the jury polled?
Of course they do.
No, Your Honor.
All right.
Oh, no.
Ladies and gentlemen of the jury, I want to thank you very much for the time and attention that you paid to this matter. The right to a trial by jury is a right that's guaranteed in the Constitution, but it's a right that we cannot provide without our citizens like you being willing to sit and serve your civic duty as jurors. I do appreciate the time that you gave this matter. So on behalf of the court and the parties, I want to thank you for the time and attention. I know that this was a lot that we asked you to do. So if you guys could follow the marshal to the back, and I will come back and formally excuse you from jury duty. All right, to the jury.
Crazy, man. He said, don't cry. I'm not crying. Hey, Lizzie, y'all telling me don't cry in the chat. I am not crying for Devyn Michaels. The evidence was overwhelming in this case, and we saw that in just the few days of we covered of this case. It's like, man, we're go ahead, lock her up.
Okay, this matter is going to be referred to the Division of Parole and Probation, set down for sentencing on.
January 8th at 9 a.m.
All right?
Thank you.
Thank you.
And I'm going to go back and talk to the jury, and the least that they desire to speak to you guys, I'll come back and let you know. It's late, I'm going to wrap them down.
Thank you.
So now that we've heard the verdict, what we're going to do next is we'll go ahead and get into the defense's closing arguments. And we're not going to listen to the entirety of it, but I want to listen to key parts. And I want you all to decide, as the jury here on this channel, if you think the jury made the right decision based on what we hear in the closing arguments, or did they maybe miss something? Let's see.
Review the evidence. There is an instruction that I think is of paramount importance in this case, and it's instruction 32. It concerns the credibility or the believability of a witness should be determined by his manner upon the stand, his relationships to parties, his fears, motives, interests, or feelings, his opportunity to observe the matter to which he testified, the reasonableness of his statements, and the strength or weaknesses of his recollections. If you believe that a witness has lied about any material fact in the case, you may disregard the entire testimony of that witness or any portion of his testimony which is not proved by other evidence.
Oh, and for those of you who are just tuning in and didn't watch this trial at all, the defense was trying to paint the picture that her stepson turned husband, yes, you heard that right, he was her stepson, and then they got married. I'm not going to give the details of that. If you want to find out the details, we covered it on this channel. So the defense was pointing the finger at her stepson husband and saying that he possibly could have been involved and that maybe Devyn was just in the wrong place at the wrong time. Keep that in mind.
I read this instruction to you with Devyn in mind. You know, we started this case talking about motivations. Motivations dictate actions. Devyn is not on trial. You know, this case is not going to be, well, did we prove our case against Devyn better than they proved their case against Devyn? Devyn is the only person that's on trial. We have gone through the evidence in good faith, and I'm going to discuss that a little bit with you today in my summation.
Yeah, please
That there
do.
is evidence to believe that Devyn committed this crime. But you don't have to believe that
There you go.
to acquit my client. But I would submit to you that you should take that into consideration. The ultimate determination that you will make is the sole judgment of the facts, whether the state has proven this case beyond a reasonable doubt. Through the course of this case, and as you know, when we talked about it, we wouldn't have to ask a single question, present a single line of testimony. If state fails to prove their case, she's entitled to a verdict of not guilty. But as this evidence has unfolded, I would urge you to see that perhaps the detectives in this case, the Henderson Police Department, were basically trying to choose the shortest distance between 2 points. I mean, hey, we knew, and we all know, and we're not making issue that she was with him on the night in question. It's easy to reach a judgment like they did. She's guilty. But you, as jurors, must consider all of the evidence. Because unlike when you read in the paper, so-and-so's caught, oh, and you think, yeah, he's guilty, she's guilty, you determine whether a person is guilty, not the police and not the state of Nevada. I would urge you to read the reasonable doubt instruction. A defendant is presumed innocent until the contrary is proved. This presumption places upon the state the burden of proving beyond a reasonable doubt every element of the crime charged, and that the defendant is the person who committed the offense. And again, this is why we have addressed what the evidence reasonably shows concerning Devyn. A reasonable doubt is one based on reason. It is
You're
not mere
blaming it on
possible
him.
doubt, but is such a doubt as would govern or control a person in the more weighty affairs of life. And what more weighty affair of life do you have than to sit on this jury on this type of charge? If the minds of the jurors, after the entire comparison and consideration of all the evidence, are in such a condition that they say they feel an abiding conviction of the truth of the charge, there is not a reasonable doubt. Doubt to be reasonable must be actual, not mere possibility or speculation. If you have a reasonable doubt as to the guilt of the defendant, she is entitled to a verdict, not guilty. Since this is a charge of murder, I'd like to begin my comments, and I won't be long. I mean, we've been here a long time, but this is important. Let's begin at the autopsy. We had Dr. Sims. He was the lead coroner here in Clark County for 19 and a half years.
Wow.
You heard his testimony. It wasn't much of a cross because he didn't say much to be disagreed with. We did, however, hear from Dr. Yagi. Do you recall the question that was posed to her? Would you agree with me that a decapitation is difficult to effectuate? Remember her answer? I don't know, I've never done one. We heard from Dr. Sims, yes, it would be difficult. It takes a lot. It's involved. Dr. Yagi missed the tattoos. It was in the report. We had Oriental John. That kind of goes to the weight that you should give her testimony and the thoroughness of her examination of the body. The state's relying upon Dr. Yagi's statement, her testimony that there was no injury on the hand. You got to consider the source. Dr. Sims testified that the cause of death cannot be determined without evidence of injury, and he was talking about standard practices. Obviously, these are very suspicious circumstances. In fact, if John was murdered, it's very reasonable to assume, common sense would dictate, that the person that killed him decapitated him. And through the course of this evidence, they have not shown a scintilla of evidence that she was involved with the decapitation. She didn't do it. Determination of homicidal violence cannot be used when in large part that fatty liver or drugs and alcohol are present. He was talking basically about the industry standards, what experts in this field collectively agreed upon. And we saw a variation in this case from Dr. Yagi. In this case, we did have a combination of all three. You heard the testimony about 20 times the level of THC, alcohol in the body. 0.02 was the alcohol in the blood, but Dr. Sims testified that that, in conjunction with this high level of THC, would cause a person to be intoxicated. That's important in this case because you will hear testimony concerning her concern, Devyn's concern about not letting him drive. As you recall, we went through all those texts beginning back in 2018 concerning Yoko's concern. And again, I don't want to speak ill of the dead, and it was no showing of disrespect towards her, but it was an ongoing concern that she had. She didn't want her son driving drunk, and that concern was shared by Devyn. She had his key. She took the key to the house. That's not evidence that she committed a murder.
Well, okay.
This is extremely important, and there's been a great deal of issue made concerning this video evidence. As you recall, through the course of Devier's testimony, I read it to you at the beginning of the trial and read it to him, where basically we had a detective, it was the 12th of September, telling him, you're under the radar. We're here to clear you. I mean, when you look at the radar, when you look at this net that was cast, it has so many holes in it. The state would have you believe that both homes were under 24-hour surveillance. It's just not true. The evidence of Detective Lippisch and the other detectives show that. The state expects you to accept representations made by Detective Lippisch regarding the true time of the videos from this residence, and I want to start there. This concerns the state's timeline, which I would tell you flies in the face of common sense, but it's important to take into. This concerns the state's timeline, which I would tell you. You recall the list of times or the videos that were shown? He supposedly didn't. It was on a neighbor's cell phone. We saw no logs. We saw no indication of the veracity or the accuracy of those times. The state's basing this idea that she's pulling up in front of the Palladera residence and is somehow moving her car at 11:04 to avoid detection. You have to take this detective at his word. And again, I'm not necessarily saying he's lying, but he did a sloppy job of collecting that evidence. And this is the video evidence that I'm referring to. Remember, there was no embedded data here. We don't have time. He would have you believe that the vehicle is moved at 11:04. We don't know what time this is occurring.
Yeah, there's no time on the
We do
camera.
know that the vehicle perhaps was moved from the Burla, but we don't know the sequence of events. As you recall, and you will have the evidence, there was various blue lines showing triangles, and we heard that through the positioning of the GPS, you have movement, even if a vehicle is in one place. We don't have specific times, and we really don't know the order of how things occurred. We would urge you to believe and to consider that common sense would dictate that this was when Devyn left the residence at 2:04. There's going to be a close-up here. You'll have a computer screen. Zoom in on it.
Car locking.
Here you see the interior of the vehicle. You see Devyn getting in. You see a bag on the passenger seat. And she leaves. Please pay close attention. And again, not that I'm trying to tell you to, but we've had this case for much longer time than you have. Look at the video evidence from 6505 Taylor Creek. Detective Lippisch testified several times that he could only speak to items that he canvassed for, but he was happy to testify concerning other detectives who went unnamed that collected this evidence. It's clear from the testimony of a forensic examiner, O'Brien, whose credentials and whose testimony went unchallenged that we presented to you today. He testified that one of the three videos was compiled from a series of screenshots, which the Ring camera is set to capture by default in the absence of video activity. Where are the other screenshots? They only gave us 3. I'm not going to stand here and point the finger and say that this was done in bad faith. It was done out of sloppiness. Why weren't subpoenas issued? Why don't we get the complete record? This woman is on trial for murder. We heard nothing concerning them going to the
Why didn't we get it?
Ring, Google, other parties. No, they're relying upon the cooperation of neighbors who are living their own lives and who very well may be indifferent to the gravity of this situation. Didn't give us the full picture, and that was the video that had constant, I mean, if you got a good scene into or a good view of the residence, it's incomplete. We just have these three. And again, this is at the new residence where it's been referred to. Porcupine here, we've got the truck.
And we saw this video too.
You know, there's been an argument made that Debbie had to have been in the home the whole time. Based on what? Because the entrance to the neighborhood, which the continuous camera doesn't show a vehicle, there's other ways to leave that residence. There's a walkway next to it, one house away. There's over the fence. This is something that's been discarded by the state, but again, I would submit to you that it goes to what Devyn is thinking. It goes to her innocence. She starts trying to contact Jonathan on the morning of the 7th, starting about 4 a.m. She'd left him. She'd left him at the residence. The plan was that they were going to take the girls to school that morning, and we have evidence, and you've heard uncontradicted evidence that that's what she did. The message she leaves him is concerning the girls' school supplies. She's letting him know that their daughter was sick, because we know that she's at that pharmacy, and it's a 24-hour pharmacy at 2:28 a.m. That's what went on. She hadn't killed him and decapitated him. She was worried about getting her daughters to school that morning. She sends messages of concern when he doesn't respond. The state claims, and again, this is where common sense comes into question, the state claims that Devyn was answering Jonathan's phone from the house the morning of 8/7/2023. You heard the argument concerning the notifications. We did hear from Detective Skinner that they didn't put it on airplane mode. Those notifications wouldn't have shown up. That evidence, like so many other pieces of evidence, were mishandled. The state's going to have you believe that she purposely took the phone from Paladera to Porcupine Rim and leave it out on the driveway, and at the same time be calling it and answering it and leaving it on the driveway. That flies in the face of common sense. She took it and left it there, and then is answering it and calling it to provide some sort of an alibi. She's lucky that in this very slipshod investigation that she has as much evidence that she does to present to you that she didn't commit this crime. Crime scene, the footprints. There are footprints in the backyard. And we have, and I'll show you the photos, we marked them and had them admitted. We have this, the Henderson Police Department documenting these footprints, but then trying to basically throw shade on that, saying, well, they could have been there for some time. They weren't important. When you look at the photo, you can see that they're fresh. They wanted to argue that they're male or female. They didn't do any follow-up. There was no footprint comparisons to anybody's shoes in this case, much less Devier's. You recall Yoko's testimony, there were 4 dogs in the backyard. If that footprint had been there for very long, common sense would dictate that the dogs would have walked through it. They would have been sullied.
Okay, all right. That's enough of this. Let me know what y'all think. Devyn's going to jail. It is what it is. I don't think the defense had enough. There was too much there showing. She's the last one there. She knew what was happening. You hear the phone call to 911. It's over. She's going to be in jail for a long time. Let me know what y'all think about this in the comments in the chat. I mentioned in the chat that in 2024, she had a plea deal for 2nd-degree murder, and she would have been eligible for parole after 15 years. Now, looking a little bit different. Did she make the right choice? Not looking like it. Let me know what y'all